The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, a weekly podcast on the Federal Courts of Appeal brought to you by IJ's Center for Judicial Engagement. I'm your host, John Ross. Today I'm joined by the dynamic duo, Evan Bernick and Clark Neely. Evan and Clark recently released a report on judicial engagement in the courts. You can find the report, entitled Enforcing the Constitution, at ij.org/CJE. This week on the show, the NSA's suspicionless surveillance, a pig on a pike, and police misconduct at a roadside stop. Clark, kick us off.
First case is an en banc decision from the Sixth Circuit, reversing an earlier decision in which a panel of the Sixth Circuit allowed the so-called heckler's veto to be applied to a Christian group that would show up at this Arab International Festival that they have in Dearborn, Michigan. It's one of the biggest events of its kind in the whole country. And a group called the Bible Believers shows up every year to essentially proselytize their Christian beliefs in the presence of all these devout Muslims. They do it with the point of being provocative. And what happened was they were forced to leave, finally. They were forced to leave by the local police, who felt that they were stirring up the crowd and creating an unsafe situation. The question was whether that was a violation of their First Amendment right of free speech. The first time that went to the Sixth Circuit said no, it was not. And we got a different decision from the en banc court.
Yeah, the original decision was an absolutely terrible decision. We highlighted in the reports as an example of judicial abdication. It was that bad. And the court in that case basically said that even though these officers the officers made no effort to protect these Christian evangelists from people who were throwing bottles, throwing rocks at them, and basically said, look, you're causing a scene. We're going to arrest you if you don't leave. That's perfectly fine. In this case, the en banc court rejected that logic, rejected the heckler's veto in a very decisive and forceful way, and set the record straight.
One of the things that's pretty outrageous about this case, or at least I felt pretty outraged by it, was how obvious it was that the police were deliberately allowing the situation to escalate, because every time they would walk over to where the Bible believers were proselytizing and getting the crowd worked up, the crowd would immediately calm down and stop throwing things. But then the police would walk away and allow it to get all spun up again. And it was 100% clear that if they had just put one or two police in the vicinity and had them stay there, that it looks like everything would have been fine. It was the police officers' deliberate refusal to stick around and help defuse the situation that really enabled it to get out of control. And that's why it really was a heckler's veto type of situation. And really, one gets a very strong impression that this was a deliberate effort on the part of the police to allow things to get out of hand, to create essentially the very basis that they then invoked for ejecting these people whose speech was certainly offensive, but nevertheless First Amendment protected. So this actually is an incredibly important case when it comes to the amount of First Amendment protection that someone gets. Do you lose it simply because you're engaging in deliberately offensive speech?
Right, and Supreme Court case law is very clear on this. The first thing that you do is you protect the speaker. Your priority is to ensure that people who aren't using violence, people who are expressing themselves in hateful tones and offensive tones, whatever they might happen to say, if they are not inciting people to violence and they're not threatening other people, the police are supposed to protect them. The police made no effort to do so. There's video of this. Apparently, there were as many police officers at this festival as the city has at the World Series, and they basically did nothing to prevent these people from being assaulted.
The Bible Believers brought their own implement, I guess you could call it, to prevent them from being assaulted. Evan?
Yeah, that's what they said. They brought a pig's head on a pike because Muslims believe that pigs are unclean animals. They thought that by waving this pig's head around on a pike, they would ensure that anybody who took exception to their message would not rush them.
So these folks were being deliberately offensive, and the police kind of took that as an excuse to avoid their responsibilities.
Yeah, and I think the police in this case probably lost a great deal of credibility with the court when the following fact came out. This is undisputed. It's part of the record. At the same time, the police claimed that they didn't have enough manpower to assign even one or two officers to the area where the Bible believers were proselytizing and getting the crowd worked up. So they don't have enough personnel to station somebody right at that spot. But when the Bible believers were finally ejected from the festival and got in their van to drive away, they were immediately pulled over by a couple of officers from the same department for supposedly having a missing license plate. And then 6 other officers showed up. So there were 8 police officers available to participate in this routine traffic stop. And yet at the same time, the police want the court to believe that they didn't have enough officers at the event to assign even 1 or 2 to this one particular area where there was clearly trouble, and where the sporadic presence of police calmed things down every time a police officer did show up. So there was, it seems quite disingenuous on the part of the police to claim that they just didn't have the resources to try to calm down what they claim was a potential, riot, but they had 8 officers available to respond to a routine traffic stop.
And speaking of vast police resources, let's move on to the Second Circuit and the NSA suspicionless surveillance case. Evan?
So this decision is a follow-on from a decision in May holding that the NSA's bulk collection of people's phone records was not authorized by Congress and was therefore unlawful. The court in that case didn't take on the issue of whether it was unconstitutional because it found that it wasn't authorized by Congress.
Can you just speak briefly about the difference between unlawful and unconstitutional?
Sure. In that previous case, the court found that the bulk metadata program had never been authorized by Congress in the first place. So it was against the federal statute that Congress had enacted. It was not authorized by the statute Congress had enacted. Therefore, the Fourth Amendment claim that the plaintiffs raised in that case, the court didn't get into that at all. Now, the ACLU is challenging the continued collection of
the metadata.
Of metadata during the time period in between that decision and the phasing out of the metadata decision in the next 180 days. And the court doesn't rule on the constitutional issue because they say, by the time we reach a ruling, by the time we make a determination, Congress is already phasing this thing out. Let's just defer to Congress.
So this represents a troubling installment in something that we've seen plenty of times at the Institute for Justice. And for people who don't litigate constitutional cases, you might not be familiar with this trend, but essentially it is the government coming up with different ways to avoid a judicial ruling on the constitutionality of its conduct when that conduct is highly suspect from a constitutional standpoint. I'll give you a couple of examples. As some of our listeners may know, we've challenged a number of ordinances that require a license to be a tour guide. Well, the first of those challenges was actually in Philadelphia, which passed a law requiring tour guides to be licensed. But then when we challenged it, they went into court and claimed that our clients didn't have standing because the agency responsible for enforcing that tour guide licensing law didn't have the funds to enforce it and so did not intend to enforce it for the foreseeable future. I'm pretty sure that if we had not challenged the law, they would have found the funds and they would have been enforcing the law. So I personally believe that was just a dodge to avoid getting judicial resolution of the constitutional issue. By the way, we've also seen this in civil forfeiture cases, not an IJ case, but the most important case in civil forfeiture on the question of whether there's a procedural due process right to a prompt hearing when the government seizes something like an automobile. That case is Alvarez versus Illinois, went up to the U.S. Supreme Court, but it was mooted at the Supreme Court when the defendant gave back all of the cars that they had seized, I think with the deliberate purpose of trying to avoid a Supreme Court ruling. And unfortunately, we've seen it in other contexts as well, the government trying to avoid a constitutional ruling when it's probably correctly suspects that it would go against the government. This seems to be part and parcel of that trend, and it's rather unfortunate that the courts seem so willing to lend their imprimatur to this kind of litigation tactic.
Right, let's be clear about what's happening here. For the next 180 days, these plaintiffs are going to be subjected to what they claim is a violation of their Fourth Amendment rights. This is a very important Fourth Amendment issue. Whether and to what extent the Fourth Amendment applies to information that's voluntarily provided to third parties is a pressing Fourth Amendment question. And the court basically ducked it and said that we are going to defer to Congress because they're transitioning out. We're going to make things easy on the government. And that is unacceptable.
Okay, let's move on to the last case from the 10th Circuit. Clark?
This is an absolutely appalling case of police misconduct. In a nutshell, what happened was a family's driving along and goes past a police officer in New Mexico. The father of the family is a former law enforcement himself. He gives the officer a friendly wave, and just on a lark, she decides to enter the license plate into the database to see if there are any warrants or if there's any reason to pull over the car. She transposes some letters or gets one of the letters wrong and gets a hit by entering essentially the wrong information about the license plate. This is a rookie police officer. She then violates her training by failing to re-enter the data and confirm with the dispatcher that in fact this is a valid hit, which was rather obviously indicated in this context because the information that came back indicated a different make and model of vehicle than the one with the license plate in question. She then proceeds to make a felony traffic stop on the presumption that the car, which is full of a family, it's a husband and wife, couple of kids, and their dog. So she makes a felony traffic stop. Some other officers show up, and this is an extremely rough, violent. There's some dispute about what actually happened, but there's no question that the entire family was taken out of the car, put down on the tarmac. Guns were drawn. There's a dispute about whether guns were actually put to the heads of more than one or more family members. And the dog freaked out and ran out into the highway. Fortunately, was not hit by a car. They were able to restrain the dog. And the question becomes whether or not, as is so often the case in these cases, were these officers entitled to qualified immunity? I would have said that I thought that asserting qualified immunity in this context, when the officer violated her training and performed a violent felony traffic stop with no basis, I would have thought that asserting qualified immunity would be sanctionable. I went and looked at the district court opinion down below. The district court actually ruled for the police officers and said this was qualified immunity.
Evan, should that be surprising?
It's not entirely surprising that the district court granted qualified immunity, given that qualified immunity has in practice become absolute impunity for constitutional violations. It is surprising and encouraging that the appellate court in this case focused on the specific facts that made it clear that it was completely unreasonable for the officers to behave in the way that they did and denied qualified immunity.
This was a terrifying stop by any stretch. One of the children, months after the stop, reports having night terrors, is now afraid of police officers. We need to understand the human cost and the human toll and how serious a thing it is to take somebody out of their car and put them face down on the road at gunpoint. That is a very, very serious imposition on their liberty, and we should hold the people who do that to a very high standard. Obviously, police are entitled to do what is legitimately necessary to protect their own safety, but they also need to understand the incredible stakes for the people on the other side, for the people who are at the other end of that gun. And I really think that this case emphasizes that it is high time for the courts to take a fresh look at the doctrine of qualified immunity, which was, of course, invented by the Supreme Court out of whole cloth. That was not a legislatively enacted policy. That was just invented by the Supreme Court. It is high time to look at the question of qualified immunity and ask whether law enforcement, which includes police officers and prosecutors, should be the one vocation in this country whose practitioners are effectively immune from all or substantially all financial responsibility for the harm caused by their misconduct. I think that was a disastrous policy from the beginning. I think it was judicial activism, which is a term I don't use very much, on the part of the Supreme Court to invent it out of whole cloth. And I think it should be reconsidered because this is precisely the kind of thing that happens when police officers understand themselves accurately to be essentially unaccountable, at least financially unaccountable for their conduct.
Evan, what's going to happen next here in this case?
In this case, what's going to happen is the officers are now going to be held civilly accountable for any injuries that are established that they inflicted upon these people, emotional injuries, if there are any physical injuries, just like an ordinary litigant in an ordinary civil case.
With one exception, an important exception, and that is the officers will not be held financially accountable. To a almost certainty, it is the taxpayers who will pay the damages, if any, in this case. There's actually a wonderful law review article that came out last year that documents that 99.8% of all civil judgments against police officers are paid by the department, which means by the taxpayers, even in jurisdictions where it's impermissible to do that. So when we say that there is virtually no financial accountability on the part of individual officers, that is not an exaggeration. It is exceedingly rare for any individual police officer to ever have to pay for the harm caused by their misconduct. Instead, the taxpayers virtually always pick up the tab. That is wrong.
And another important point to make is that juries do not necessarily know this. In fact, they often do not know this. They assume that the officers are going to be paying out of their own pocket for any civil damages that are imposed upon them, when in fact most officers are indemnified against civil liability for tort claims, and therefore taxpayers end up footing the bill.
And let's take that one step further. We as public interest lawyers have to carry malpractice insurance in case we mess up. Doctors have to self-insure. Everybody except law enforcement has to self-insure. Imagine the wonderful discipline that it might have on the occupation if the expense of insuring yourself was related in some way to the amount of misconduct committed by other officers in your department. That might well have a salutary effect in getting officers to clean up their own act if money came out of their pocket in terms of how expensive their malpractice coverage or their liability coverage was. But of course, the Supreme Court has completely severed the link between officer misconduct and officer liability by inventing the doctrine of qualified immunity out of whole cloth. It was a mistake at the time, it's a mistake today, and it should be undone.
Okay, that concludes the show. As always, thanks for listening. For more judicial engagement, check out Evan Bernick's columns on the Huffington Post. To find them, Google Evan Bernick and Huffington Post. You'll be glad you did. Until next time, this is John Ross from the Institute for Justice, politely prodding you to get engaged.